Okay, great. So good mornings to those of you who remembered and joined this call this morning. You know, we've been having our chamber events, and I think everyone knows me on the call, so I don't need to do a formal introduction, but we've been having our chamber events this past month. And as you know, October 1st, there were a number of new laws that went into effect. And some of the chambers, surprisingly, some of the businesses were like, oh, I didn't know that. And, you know, a lot of them were just smaller businesses that may not have a full-blown HR department, or the operators, doing payroll and running their shop. So we thought it'd be good to get Gary on here. And for those of you who don't know Gary, he is a shareholder over at Mitchell and Sheahan. Their office represents employment law. He represents employees and employers in a wide range of matters, including disability and age discrimination, family responsibilities related to discrimination, wrongful termination, and severance negotiations. They've been a great partner of ours over the years at the BRBC and our affiliated chambers, so we're always grateful to have Gary's knowledge and expertise shared and anything employment law related. So Gary, thank you and welcome this morning. And we also have Eric Gjede, who I personally have enjoyed working with over the last year, especially the last session. As you folks may know, he's the Vice President of Public Policy over at the CBIA, the Connecticut Business Industry Association. He's got a great team there. They've been very supportive of our Government Relations Committee at the BRBC, and just grateful that he's spending some time with us this morning as well to talk through some of these changes. I think we've got a pretty good lineup of discussion points. I think Gary helped us itemize about 8 different talking points, starting with the vaccine and COVID and ranging all the way to the cannabis stuff that I know some employers are curious about. And these are relatively new things to us, so how do we address them and deal with them from a business perspective? So I'll stop there and again, welcome Eric and Gary. And I think we want to just tackle the vaccine and COVID stuff first, right, Gary?
That's correct, Dan. All right, thanks for for being here. Even though most, I think all of you don't, your workplaces are not 100 or more employees that will be subject to the the path out of the pandemic action plan. It's still, I think, whatever the OSHA, which is expected to issue guidance, some are saying by the end of this week, I think it's going to influence any developments for employers of all size going forward that implement a mandatory vaccine. So I think I'm going to go over less of what the law says and more what the issues are that we'll have more development on. Also, and because we're in sort of this kind of holding period, what I'm going to do also on this, as well as all of the other, the 7 other topics we're going to be addressing, is to put together something in writing that can be circulated. Now, what I'm going to do is just focus on the law, and then Eric's going to talk about sort of the, from an employer's perspective, what he's hearing on each of these topics. So as far as the vaccine mandate, the OSHA is developing an emergency temporary standard for employers with 100 or more employees. There'll be a vaccine mandate, or in the alternative, weekly COVID testing. First thing is just with many employers already have mandatory vaccine policies, and most of them, not all, but most are, if somebody they have to request a religious or medical exemption. I think whether that might not be as prominent, even though I think that policy is more effective than more of a choice between COVID testing and mandatory vaccination. But I think we'll have to see whether or not that kind of becomes the norm, is just what I think is more of a choice rather than a mandate. We'll talk about those 2 exceptions later. Second issue is remote workers. Does the vaccine mandates apply to unvaccinated employees? In particular, do they have to get, can they forego COVID testing since they're not in the workplace? Third is who pays for the weekly COVID testing. Again, it's not, there's not as many facilities available with, where you can go to get free COVID testing like used to be the case. I know I paid for one in Westport, $125, where I needed to get a same-day test. And so that, again, is an issue that will presumably be addressed. Also, whether it's same-day testing or the PCR testing. Fourth issue is whether or not this is good or bad, because with a lot of employers would like to implement mandatory vaccines, but they're concerned with, they're going to lose employees to competitors, lose customers. And so some employers are kind of grateful for the mandatory vaccine, because then at least they have someone to blame named Biden. So they don't have to say that, this isn't us that's doing this. The fifth issue is with respect to 100 or more employees, how is that defined? Is that facility-wide? Is that company-wide? The sixth is I think these issues are going to really come up with, regardless of the size of the employer, is whether or not where somebody takes time off to get the vaccine, is that considered time worked? If it's time worked, they have to be paid for that time. And the kind of the philosophy before the from the Biden plan is that this really be seen as part of work. So the likelihood is that the guidance is going to be that employers have to pay for that time where they're going out to get COVID testing, or I should say to get the vaccine. What's going to become a bigger issue from a time standpoint is whether COVID testing, the weekly COVID testing is considered time work. Again, that's something that if that is and something an employer is offering as an alternative or as an accommodation, is whether or not they have to pay employees for that time. You kind of have, sort of a reverse incentive. If somebody can just be out getting COVID testing and not working, getting paid overtime, it's kind of a reverse incentive to getting the vaccine. The eighth issue is with respect to unions. What role does unions have here? Some unions have been filing legal claims, most unsuccessful, but collective bargaining agreements, which cover terms and conditions of employment, generally cover things like testing of any kind. So a lot of that's going to depend on what the collective bargaining agreement says. The last issue that I think employers have to be concerned about is court challenges. Most of them have been unsuccessful, but unless there's kind of an overreach. For example, New York State, with healthcare workers, they have essentially taken away the religious exemption, and that has so far the court challenges New York State's been losing. As to medical, the exemptions from that are required by the EEOC is both the medical exemption if someone can't get a vaccine for some sort of medically related reason, or the religious exemption. I know with our clients, both employees and employers, there's certainly the religious exemption seems to be much more prominent, and that relates to sincerely held religious beliefs. Now, I think it's important to keep in mind, because you think religious beliefs, the person has to be in a religion. The EEOC guidance actually points out that it doesn't necessarily have to be any organized religion. Someone who is agnostic may still be entitled to a religious exemption. And the focus really is on whether it's sincere. The guidance from EEOC really also talks about moral beliefs. So it's kind of intertwined, and it's called religion, but I think it's important to keep kind of a broader perspective. What the EEOC guidance says is that you can question, you don't have to necessarily accept what they're saying, but if you're going to challenge it, there really has to be an objective basis. One thing, for example, employers are asking is, have you ever objected to any other vaccines in the past? Certainly, I think with respect to what we're advising clients is to err on the side of caution, because turn down an exemption person is likely going to be terminated, that's when they may file with both the CHRO, and the EEOC for religious discrimination. Now, if the exemption's granted, then you focus on what are the accommodations. And again, depends on the nature of the job, depends on the nature of the workforce. Also important to keep in mind that, for medical exemptions, that's more of the typical ADA analysis. As far as religious exemption, even though the terminology is the same, is it an undue hardship? The law supporting that is for religious exemptions, it's not as onerous on employers. The terminology is a de minimis, a minor change. So again, I think we will, it's important, I think, to keep in mind in Connecticut, a lot more receptivity to vaccines in Connecticut than there is elsewhere. According to, right now, the most recent survey I've seen is 68% of people, support mandatory vaccines. So, if you're doing business in Connecticut, it's not like doing business in Alabama. And so I know I've had calls from people who are, because I know there's genuine concern of, are we going to lose people if we implement it? I think some employers should consider in Connecticut is, are we going to lose employees if we don't implement a mandatory vaccine? And so the last, before I turn it over to Eric, is I think there's reason for optimism. One of the leading players in this, COVID arena is Dr. Scott Gottlieb from Westport, who has been incredible at predicting what in forecasting what we're going to be seeing next. He's now saying we're on, after we get through the downside of Delta, there doesn't seem to be anything imminent. So the likelihood is we're going to gradually go into, where it's, I don't want to say post-COVID, but not in the crisis stages we've periodically been going through. That's all I got. Eric.
Yeah, and Attorney Phelan, thank you very much for that. And I think you really summarized the biggest issue here with, you rattled off, 10, 15 questions that employers are struggling with. And right now, that's the biggest concern of the business community as it relates to these vaccine mandates is, what is this guidance going to look like? What is it going to say? What requirements will be imposed upon the business community in order to enforce this new requirement? The president made this announcement. It's got to be over 2 weeks ago now, and we've all just been patiently waiting for answers to those questions you rattled off. And you made a number of points that I was going to make as well, that in Connecticut, at least according to the surveys of CBIA's membership, just slightly more than a majority actually support these mandates. And I think it's exactly the reason that you sort of got into at the end. Businesses in the state, we've only seen about a 69% job recovery for all the jobs lost due to the pandemic. And right now, businesses are just scratching their heads, trying to figure out how to get people to come back into the workforce. And we have just as many people who are saying, well, I'm not coming back if I'm going to be required to have a vaccine. You have just as many people saying, well, I'm not coming back unless everyone's got the vaccine. So there's really sort of a no-win situation right now for the business community. So I think in some respects, they really welcome this new vaccine mandate, or especially the larger businesses that have been contemplating implementing one on their own. Now, the good news in the state, and I think you touched on this as well, is that we are a relatively highly vaccinated state at this point in time. According to the surveys of our membership, at least 75% of all employees amongst our membership has had at least one vaccination. 67% are fully vaccinated, and we're only second in the nation behind Vermont. So I think we've done a pretty good job at this point in time. And then, what the future looks like is also something that I think a lot of employers are contemplating. Now, at this time last year, about 72% of businesses in the state had some sort of hybrid work model, but that seems to be going away, where about 83% in our most recent survey now say they're not going to have a hybrid work model in the future. So more and more people realized that, while we needed that hybrid model to function in the past, you do lose a little something there. You lose collaboration, you lose, the team building aspect of the workplace. So, businesses, in addition to all the other things they're struggling with, they're worried about some of those issues as well. So.
Okay.
Thanks, Eric and Attorney Phelan. I appreciate that. Yeah, one thing just to echo the confidence that businesses are, at least from what I'm hearing, businesses are aligning with the governor and what the federal government's forcing, not forcing, but making a mandate is it's better to follow policy that's clear, right, and a decision that's made. Like, look, you could point, I'm not the bad guy. This is the requirement by law. And it makes it easier for them to operate their businesses, especially like the retailers, because they're like, well, why do I have to do this? And well, it's required. And it's better than, at one point, I think it was a little bit fuzzy where it was up to you as the business owner. And then it went down to the municipality level where, do you wear masks, not wear masks, those kind of things. And it's just better if it's just a blanket. At least whether you agree with it or not is another thing, but at least there's consistency and that's what the requirement is, and to follow that. So I agree with what Eric was saying and Attorney Phelan with what I'm hearing from the business community as well. Okay, great. So moving along, I think we're going to take some questions at the end, right? Is that how we thought we would do this? Great. So just moving along, because there are a number of other items that went into effect on October 1st. And one of them is around age in the application process. So we'll start there, and then we'll kind of chip away at the list of items that have surfaced since October.
Okay. The Connecticut Fair Employment Practices Act was amended to prohibit employers or their agents from requiring or requesting that the prospective employee provide their age, their date of birth, or their date of graduation from an educational institution. Now, if somebody voluntarily provides it, obviously you can't prevent that, but it's very important to review your employment applications. We've had a couple of clients who didn't even realize they asked that on their applications. The two exceptions, one is, the BFOQ, any bona fide, occupational qualification or need. If there's a minimum age, I think let's say a job has a minimum age of under, you have to be at least 21. I would not ask for date of birth. I would ask a question, phrase it of, are you over 21 years of age? Just because that's a requirement. The second is when such information is required to comply with state or federal laws. One of our clients, for example, there's a mandatory background check. Background checks generally require date of birth, but like most exceptions are often going to be interpreted narrowly. So also important to notify third parties. If you use headhunters or recruiters or post things, for job sites, be very careful what they say or what you tell them, so they are not making any kind of references to requirements of date of birth.
Yeah, not a lot to add on this one. CBIA was involved with some of the negotiations on this bill very early on. It actually was not new this year. It was really new in the 2020 legislative session, which ultimately ended after just a couple of months due to the pandemic. I think that in most cases you probably didn't have your date of birth on your employment application at this point, but the dates of attendance at higher education institutions are probably where people may have to make some changes. There is a little bit of concern. When we were negotiating this, we had to push back and obviously get the bona fide occupational qualification exception, get it so that you could ask, just as Attorney Phelan said, are you over 18? Are you over 21 on the applications? There was an effort by some groups that wanted even broader restrictions on employment applications and job postings. They wanted to ban certain terms within those job ads, like things like a digital native. You know, if you're putting that in your employment posting, they wanted to ban that type of thing because that sort of hints that you're looking for someone who is a younger worker. So we saw that that would just lead to a host of issues for the business community. And frankly, I didn't even know what a digital native was. We ended up managing to hold the line on that, but this could be an area where there is additional activity in future legislative sessions. I think it's in a pretty good place right now. I think the proponents of this legislation were very happy to get this across the finish line. But again, there are always those who are looking to push a little bit further. And so this is something that we are in the business community are certainly going to be keeping an eye on in the future.
Great, thank you. Now, this next one I didn't even realize was an item until I saw it. The Crown Act. Can you give us a little background on that? That'd be appreciated.
Sure. The Crown Act stands for an act creating a respectful and open world for natural hair. Connecticut became the 9th state. Some municipalities have also passed it. It amends the definition of race discrimination in the Connecticut SFIPA, expands to say race includes inclusive of ethnic traits historically associated with race, including hair textures and protective hairstyles. Protective hairstyles is defined as wigs, head wraps, and hairstyles such as individual braids, cornrows, locks, twist, bantu knots, afros, and afro puffs. So again, it's it's important to review grooming and appearance policies so as it doesn't sort of encroach upon any of these that definition. I think it's also important to train HR. Again, I think overall, there's been such a focus on COVID and testing and all the other issues. A lot of legislation has been passing and people aren't really necessarily aware of it. This is one of those statutes. And so important to train supervisors and HR people about this statute.
Yeah.
Can I step in here for a second? We don't require or limit any hair fashion. It's not a problem, but I'm a machine shop. You are required to put your hair back away from your face. They lean into the machine. If the turret is running, there's a possibility that their entire scalp can be removed. We don't want that to happen. So we protect our employees by requiring them to either put in an elastic band or whatever, but their hair fashion must be behind their back, away from their face. Thank you.
Yeah, Chris, I think that's perfectly fine. That's a policy that applies to everyone, regardless of hairstyle, and I think that's consistent with the law. Obviously, safety is got to be maintained as well. But as Attorney Phelan said, this is something that is happening in multiple states, so it was not unexpected that Connecticut would make this move this year. So back to you, Dan.
Thank you. Yeah, that was one of the ones that I didn't realize it was even a discussion point until I saw it. Like, wait, what's this? So yeah, thanks for going through that. I appreciate that, just for my own knowledge. The next one is disclosure of salary ranges. I know this is an interesting one as well, because this changes a lot of habits. I think that from a hiring perspective. So this is, I think, an important one to address as well.
Okay, this is the one I think is the most sort of practical, besides vaccine developments, has the most practical effect of changing sort of the day-to-day HR function. It's the disclosure of salary ranges required now by the Connecticut Department of Labor. I'll go through just some the basic elements. Employers are required to provide the wage range for positions. And that's to people who are seeking to fill a position or when offering a position. Also, when it relates to applicants, but it's not limited to applicants. So if a current employee is, for example, seeking another position, they have a right to that information. Now, again, that's something that, wage transparency is not the traditional practice throughout, most workplaces. So I think this is going to be a, kind of changing the culture with respect to discussions of salary. This, when I was brought up, is you don't ask about that stuff, but now you have a legal right to do that, at least in Connecticut. The underlying belief behind this is that the lack of information has the effect of discriminating based on gender as well as based on race. So that's what is more the catalyst for it. The hardest part, I think, is describing, what is a range of salaries. How it's defined, wage range, the range of wages an employee anticipates relying on, or an employer anticipates relying on when setting wages for a position may include any reference to any applicable pay scale, previously determined range of wages for the position, the actual range of wages for employees currently holding comparable positions, or the employer's budgeted amount. Again, it provides a little more clarity, but there's still some ambiguity that I think we're going to have to just be kind of muddling through over the next year or so till we see what's kind of the general guidance. The Department of Labor at the end of September did issue a little additional guidance to say that it refers to employers, within the state, that if somebody outside of Connecticut is applying for a job to work remotely, you also have to provide the information to them. And discretionary pay, things like bonuses, you're not required to disclose that information. And the third is just that it applies to, you don't have to sort of provide the range of wage range for all positions, just the position for which the person is applying or is seeking. And so I think what would be, and it's a powerful statute, there's a 2-year statute of limitations. If somebody were to prevail, they would recover compensatory and punitive damages as well as attorney's fees. Generally, definitely don't want to terminate somebody because they request this information or remove somebody from the hiring process. I think when somebody has made an offer letter, there should be not only, to say, not only here's what you're going to be getting, but here's the general range for that position. I think pay scales for positions are going to become important because that's, again, an objective thing you can rely upon. But and really for employers to re-examine their pay practices. Eric.
Yeah, thank you. And without question, of all the bills that we are discussing today, this one is the one I've gotten the most feedback on. And it was funny, even during the legislative session, we would put this out there for CBIA's members to review, and we would get very little feedback, but I could just tell that this was going to be a significant problem for folks in the future. And, when you have legislative leadership coming to you and saying, look, we're going to pass this thing one way or another, so make it better or live with it as is, we did our best to try to water this thing down. Unfortunately, as Attorney Phelan said, still some ambiguity in the first section that is a little bit of problem related to disclosing these salary ranges. So really, as he said, there's 3 times that you are really required to provide anyone with a salary range. When an applicant asks for it, or when you're offering the job, whichever comes first. Whenever an employee is promoted to a different or given a different position, and then any other one single time during their career, they're allowed to come to you as the employer and ask for that range. And as he said, what a range is there's a couple items that or a couple of descriptions of what that could be. Is it the range of people doing the job now? Is it the pay scale or the budgeted amount? So, you tell your HR person, look, I've got 60 grand to go out and hire this person. So that's, I guess, the range. There's not really a range. It's just, that's the budgeted amount I have to provide that person. So in terms of the feedback we're hearing the most, I think is, one is that, employers, they don't have a set range for a particular position. They put out a job posting, a bunch of people apply, and they see, oh, well, this person has these skills, this person has all these skills plus more. I like that, so I'm going to give a little bit more to the position than I might have initially. So, they may not have had that pay scale in place. And so, as Attorney Phelan said, that's something that maybe more employers are going to have to start looking at in the future. The other problem, of course, is that, many employers are saying this is going to undermine competition. And I think that gets at the guidance that came out from the Department of Labor. Now, we had some member companies providing feedback on that guidance and saying, look, when you define the word applicant, as in any applicant can ask for a salary range for a position, it really should be qualified applicant. This person has to at least have met the skills where you're offering them some sort of job interview or some sort of follow-up before they can ask for that salary range. And the department agreed with those companies, and then of course went ahead and just used the word applicant rather than qualified applicant. So now you do potentially have the situation where anyone can apply to any host of any number of jobs at a particular company and request immediately that salary range. So really you can undermine your competitors. Do I think people will actually go around and do that? No, probably not, but I do think that is the concern. Again, this is an additional workload for a lot of HR employees out there that I think they're concerned about that as well. So it's certainly something that we may have to revisit in the future, or at least get some additional guidance or narrowing of what is an applicant at some point.
Thank you for that clarity. Yeah, I was wondering if that this particular disclosure was related to advertising of jobs, but it seems like you don't have to necessarily disclose the wage in the advertisement.
No, and I guess that has provided some, we get really two reactions from people who are absolutely, completely upset that this bill passed, that it's going to be a lot of work. And then you have, especially larger companies that have multi-state presences where they're like, well, yeah, but this is way better than all the other states we're in, where we have to put the salary range in the job posting itself. And at least in Connecticut, we don't have to do that. So, again, it's mixed reaction, I think, really based on the size of company and whether you have a presence in multiple states where they've already been dealing with this issue.
Yeah, great. Okay, so moving along here, the next one is something that I came across at my corporate job, lactation. We had relocated our offices from Milford, Connecticut to Shelton, and we were building out some new space. And there was a lot of requests for a wellness room. And, I was running operations like, a wellness room? What do you need a wellness room for? Well, here you go. Now we have it. So I love to hear Attorney Phelan's itemization of the lactation law that went into effect.
Okay, now we're going to be moving on to laws that were passed in July 1, but also got very little attention, and that I think a lot of employers are still not aware of. This is called an act concerning breastfeeding in the workplace. What the previous law required a room or location to be private in close proximity to the work area, not a toilet stall. The new requirement expands that to say the room must be private, preferably with a lock. Secondly, that the employer has to either buy a refrigerator or allow the employee to provide some sort of portable cold storage device where they can store breast milk, and also access to an electrical outlet. So not a major change, but still something that people need to be aware of and make those changes.
not a lot to add on this one either. You know, we thought these were reasonable requests, especially in this day and age. You know, we didn't really put up much of a fight in this. I mean, allowing a lock on the door and not being in general public and having access to electrical outlet and someone bringing in their own cooler didn't seem like that big of a problem for us. So we were supportive of this measure.
Great. Thank you, gentlemen. The next one's the cannabis and smoking. This is one that we, you know, again, at the chamber meetings earlier this month, we were definitely hearing some questions around that. So I look forward to the conversation here.
Okay. There certainly is going to be changes with respect to the, you know, recreational cannabis, but the changes are not going to be going into effect till July 1, 2022. You know, so that's really, you know, what we're advising clients, at least now, is to follow the basic principle that you do with alcohol use. You know, is that if it affects the, you know, working, you can still, you know, take disciplinary action up to and including termination. It's really, you know, no different, at least in the short term. That the more important, and that includes, you know, that includes use of medical marijuana. Now, there is going to be, you know, as far as next year, not to go into great detail about it since it's kind of on the horizon, you know, but you can say, you can, as long as you have a written policy, employer can prohibit the use of cannabis even outside the workplace. But, you know, what I think is more important is now to look at your drug and alcohol policies and clarify with employees what you do and you don't require and what you expect of them. Because I think sometimes there's almost like an expectation on the part of some people in the public, well, so it's legal now, so, you know, my employer can't terminate me because of it, and that's not necessarily the case if it's affecting your ability to work. In the short term, what I think are the more important provisions is with respect to the smoking. Employer must ban smoking and e-cigarette use of tobacco and cannabis anywhere in the workplace. To ban smoking inside and outside the workplace within 25 feet of a doorway and or any sort of vent. Also, an employer can ban smoking entirely on the entire facility. Again, I think it's important that what we're advising is just to remind employees of any existing policies against the use of drugs and alcohol, and update when we get into next year to update the policies relating to the legalization of recreational marijuana. Eric.
Yeah, thank you. So first of all, this was a massive piece of legislation, and what the part that Attorney Phelan just touched on was probably only 2 to 3, maybe 4 sections of what was, I think, like 175 section piece of legislation going well over 300 pages. And it's very much, I think we're going to see a lot of shifting sands on this as time goes on. You know, certainly the business community had concerns with the passage of this bill, you know, just in principle, because, you know, especially for our federal contractors who are already having a difficult time finding employees. They were having a difficult time finding employees even before the pandemic, let alone now. This is going to be a real problem, and it's going to cut down on the available number of potential employees as more people begin to use the recreational marijuana. Now, so we approached it as, look, you know, we do not like this bill, but if you're going to go and do it anyway, which is what they were going to do anyway, at least keep in place the ability for employers to have a drug-free workplace, just as every other state that has gone down this road has done. And thankfully we were able to do that. And I think a large part of that was because there was so much legislative focus on the social equity aspect of who could get these licenses to produce the recreational marijuana, that there was not really much attention paid to the employer protection pieces of it. So I do think, unfortunately, those are going to be revisited at some point in the future as this industry gains its footing in the state and expands and becomes a little bit more, I guess, socially accepted. So we still have to worry about that in the future, but at least right now, for the most part, it's status quo as long as you are enforcing and reviewing with your employees your current drug policies. And we'd like to keep it that way for as long as possible.
Great, thank you. Let's move on to the sexual harassment training. I know last year, or actually I think it was pre-pandemic, there were some requirements of getting everyone trained on sexual harassment, and that was pushed out with the pandemic. Curious to hear about where we are with all that.
Okay, the one minor change that's been made with respect to sexual harassment training is that employers now are not required to provide training to an employee who's received such training within the past 2 years. But that must have been training that was either provided in person or online from the CHRO. And if another, so if they got the training from some other third-party vendor, they still have to go through the, new employer's training. We've sort of, I'd recommend just have them go through the process. It just reinforces for this new employer that this is important to us. I don't think it sends the right message to say, you don't have to, you have this training, you don't have to get it. I'd rather be someone who does more than less, advising clients to err on the side of providing more training. And, people may not remember even who they got the sexual harassment training from. Eric.
Yeah, Attorney Phelan, I think you nailed it right on the head there. So nothing for me to add. I mean, I obviously don't like the fact that only the training provided by CHRO and not a private provider. It can last for 2 years and extend to a different employer. But as you said, it's really about covering your bases here, and I'd err on the side of caution. So
great, thank you. And finally, the rehiring law, the Connecticut rehiring law. I know that is going to impact everyone as we try to get more people back into the workforce here. That were impacted with the pandemic. So this is another good one.
Okay, again, this was a statute passed in July that also did not get much of attention now. And I think it's gotten the most attention just because the first lawsuit filed under the statute was filed on October 1st. The title is an act requiring employers to recall certain laid off workers in order of seniority. Connecticut, I think, needs to get shorter names for statutes. But anyway, I digress. What this means is employers that cut jobs due to the pandemic must offer senior employees their jobs back once they start hiring employees back. But as much as it's senior employees, it's really not necessarily senior. It's because the definition of laid off employees is any employee who was employed 6 months or more in the 12 months preceding March 10, 2020, when they were, after which they were separated from service or where they were failed to schedule customary seasonal work. That was due to either the lack of business or reduction or some sort of furlough in the workplace due to COVID-19. And we know that that's a lot of employees. I think in particular where this is going to have the most effect are anything relating to the service industries, because in the short term, they certainly had a lot of layoffs, a lot of furloughs. And so what an employer is required to do is to, within 5 days after the position becomes available, to notify the laid off employee that their position is available. They have to do that by sending a letter to their last known address, as well as if they have information, if they have access to their text numbers, to text them that information. then the employee has 5 days as to whether to accept or reject the offer. I think, again, this is an area where you don't necessarily just do the minimum. Really reach out to these employees. And then but if for whatever reason the employer declines to hire the former employee, the laid off employee, you have to, within 30 days, provide them why such person was, you have to tell them why they weren't rehired. It's, and then once they are rehired, you have to permit them to work at least 30 days. And in that 30-day window, they can't be terminated unless there's just cause to do so. This is an area where I think employers are vulnerable, because a lot of employees, I think employers, if otherwise they were choosing who to lay off, they were mainly sometimes problem employees. And so but here it isn't like, there's a gradation of, your A players, you have to hire them back, but not, not the C player kind of thing. They're all considered the same level. And so, and the penalties are significant. You have to, a laid off employee can file a civil action and may be entitled to either reinstatement or rehiring, back pay offset by any interim earnings they may have received. And that would include unemployment. Also, compensatory and punitive damages if the employee shows that the employer acted with malice or reckless indifference, as well as their attorney's fees. So, and the lawsuit that was filed, first lawsuit was filed against a McDonald's franchise by 3 employees against the McDonald's franchise in Darien on I-95. And those employees have also, because it was an attempt to unionize at that workplace. So those employees have also filed an NLRB claim for retaliation that that's also why they weren't rehired. And so if those, that's a good example of where they probably, if they were to prevail under this statute, if the union animus had any sort of was a factor in that decision as to why they weren't rehired or offered rehirement, there's likely they'll be able to show it was done with malice or reckless indifference. Where I see where employers are vulnerable is if they ask some employees to come back, but not others. That's very good evidence to show that was somehow, done with malice or reckless indifference. So this is kind of a, where I think it may also have a major impact on HR, in particular, industries like restaurants, but really in a lot of industries, because again, there was such widespread layoffs. Eric.
Yeah, really great job summarizing this piece of legislation. It's just a really poorly thought out bill passed in the final hours of this last legislative session. It's something that we have been warning them about, that it just didn't make sense. And I think this gets at a problem that we had started to discuss before most of you joined us, that, the legislature goes and passes these pieces of legislation, but there's really no effort to educate the general public that these new requirements are in place. And so, just as Attorney Phelan said, you've got this case now where it's likely that these franchise owners had no idea that they had this new obligation to not only send a letter to former employees saying that, we'd like to have you come back, but you're also required to send them a text message if you have that information. So I think you're going to find that more, some of the targets of organized labor are going to be caught out as a result of this piece of legislation. Now, I guess the good news when it passed was that the time period that this applied to ended on May 1st of 2022. Unfortunately, in that same press release, or I guess news article that announced that the first lawsuit had been filed against those McDonald's franchise owners, the proponents at the General Assembly and the Labor Committee said, well, this is exactly the reason we passed this bill. And if anything, it just shows that we need to expand this and make it so that, there's a longer time period where it applies. And so I think it's their intention to come back in the coming year and expand this and make this maybe possibly a permanent requirement going forward. And that would certainly be a problem, I think, for more people, especially if they expand it beyond just the service sector industries that it currently applies to right now. So that's what keeps me up at night about this piece of legislation. So.
Thanks, Eric. Just a quick for my own clarity. So right now, the way the bill is written, it really only extends out to May 2022. So say it's, July of next year, and then you're going to be rehiring or hiring for a particular role, similar role, that the employer is not obligated to go back to those people after that point?
They may be,
right, or no?
I think it's to any layoffs that occurred between March 10th of 2020 and May 1 of 2022. So,
okay. Yeah.
So you may still, but I guess the pool of potential employees that it could apply to stops expanding after May 1st of 2022. And certainly, Attorney Phelan, you correct me if I'm reading that in an incorrect way.
Oh, no, you're correct. That's accurate.
Excellent. Well, thank you, gentlemen. That was good for me, and I'm sure for the folks on the phone here to itemize that stuff. I guess we'll open it up. We have about 6 minutes here. We'll open it up to some questions for you folks that are on the phone. I'm sure Chris and Chuck probably have something. You guys are usually good for a question or two. And Peter. Go ahead, Chris.
Oh, I'm very satisfied, and thank you, gentlemen, for so clearly stating these laws. I have some changes to make in my employee manual. I appreciate it.
Thank you.
Yeah, I have a question that I'm not quite sure how to pose it, other than some of my clients, smaller clients, have questions about liability if they refuse service to customers who come in unmasked and can't prove they're vaccinated. Are there any guidance or thoughts around what they should be thinking about, or what their standing is in regards to that?
There's no real, statute that addresses that if you have a vaccination policy. Now, one thing they might want to consider, some restaurants have done this, is to offer COVID testing on site, or where some of these tests that are available now, they're not free, but that's one thing. Or to tell them if they'd like to come back with a positive, a negative COVID test, then that also might be another alternative. I think that's better, but I haven't seen any, at least in Connecticut, any lawsuits filed on that basis. If you follow this, I feel like a pandemic lawyer is, there may be lawsuits filed over everything. So, but that's what I would advise them to do, is at least offer that option.
Great, thank you.
Peter or Andrea, do you have any questions for Attorney Phelan or Eric from CBIA?
Thank you, by the way. It was very informational, and certainly some of the issues you pose have kept me up at night too as a hiring manager. So thank you for a lot of the clarification. So one of the things that relating to the salary range in the financial services sector, a lot of times we get, it's not so much of a W-2 role, it's more of a 1099. But there is a certain fixed payment that we offer to these trainees to become financial advisors. So does the new law speak to anything regarding that?
That might be considered some, fall under the scope of discretionary income. But if it's something that's offered like across the board, not discretionary. And so I really, Eric, I'd be interested in your response, but to really keep to, just basic compensation, salary, hourly rate. Again, it depends on the nature of like if you have a signing bonus, I think that again is not discretionary. If the signing bonus may vary, then I think it is discretionary. So that's why I really think the focus is on whether or not the form of compensation is discretionary or not.
Yeah, that's my read based on the limited guidance that was put out just a few weeks ago. So yeah, I concur.
Thank you. Aaron
you.
or Andrea, you have any questions?
No, it's very informative. Thank you very much for this.
Great. I just had, go ahead, Aaron, sorry. I see you on
No, I was
mute.
just going to add that I thought this was wonderful. Thanks very much for joining us today.
Great, thank you. I just have one final question related to the rehiring law. For instance, say you had a position and fulfilling a particular role that was a full-time position, and now coming into the next year, you don't have necessarily the budget to rehire or to put that position full-time, but create a part-time similar role. Is that still part of the requirement to go back to that former employee since the role might be similar or there's some crossover?
I'm not sure. If I were advising a client, and other than looking, to see if that question is answered, or if it's not clear, which, as we know, Connecticut legislature is not always clear on the practical side, I'd err on the side of saying to offer it. Because then at least you're at least protecting yourself. Eric?
I would agree, because I believe the statute says it's not just the job that the identical job that the person had that you have to contact them about.
Right.
You also potentially have to contact them for anything that may match their skill set. So even if this job is, a part-time job, it could very well match the skill set that they had, and therefore would put the requirement that, you send them a letter and the text message. So I would definitely contact them, regardless of whether there was a change in the hours or other slight change to the position.
Great. Thank you. All right, if there's no further questions, I just appreciate your time as always, both Attorney Phelan and Eric Gjede from the CBIA. Always very informative and valuable conversations. I'm sure, Eric, you and I will be talking soon with the government relations stuff, picking up ahead of the next session.
That sounds great.
Yeah,
and thank you so much for the opportunity to come speak today. I really appreciate it.
No,
I echo what Eric's sentiments.
My pleasure, gentlemen. Thank you very much. And like I said, I'll probably forward this. I know we had about 14 or so people register. I'll probably forward this video, if you folks don't mind, to them, just so they can kind of follow up and if they have any questions, they can follow up with you directly.
That's fine.
All right, folks, have a great week, a great day today, and a great week ahead. And if there's any questions for anyone, you know how to find me. I'll talk to you all soon.
Thanks.
Thank you.
Bye now.